Hello, good afternoon, and welcome to this very first virtual tech talk from the Friedrich-Ebert Foundation's Competence Centre on the future of work. My name is Samuel Stolten. I'm a tech journalist here in Brussels, and I shall be the moderator for today's session, in which we shall home in on the EU's plan to regulate some of the world's most powerful tech companies in the form of the Digital Services Act. As part of today's panel, we will bring together some of those at the centre of the debate to shed light on what the DSA is exactly about and how it will affect the EU's digital economy of the future. As always, you can get involved with the conversation by posing your own questions to the panel using the Q&A functionality on Zoom. And we are also offering German translation, so feel free to switch between the English and German channels as necessary. Today's event will also be recorded for future reference, and do also join us on Twitter by using the hashtag FES Tech-Talk. But before we embark on our panel discussion today, I'd like to pass the floor to the Friedrich-Ebert Foundation's Matthias Weber for some welcoming remarks in German. Matthias.
Vielen herzlichen Dank, Server. Das war eine tolle Einleitung und hat auf jeden Fall den Boden gesetzt für, glaube ich, eine spannende Debatte nachher. Ich will es mir aber trotzdem nicht leben lassen, Sie im Namen der Friedrich-Ebert-Stiftung alle und auch im Namen des Kompetenzzentrums alle sehr herzlich zu unserer ersten Ausgabe dieses Tech Talks willkommen zu heißen. Besonders begrüßen möchte ich an der Stelle dann auch nochmal MEP Tiemo Wölken, Athina Angeliki Tsitsou von der Europäischen Kommission, zuständig unter anderem für den Digital Services Act, und Aída Ponce del Castillo vom ETUI, ebenfalls oder auch eine Forscherin, die sich bereits lange und intensiv mit diesem Thema auseinandergesetzt hat. Mein Name, Samuel hat es schon genannt, ist Matthias Weber. Ich leite seit September letzten Jahres das Kompetenzzentrum zum Thema Zukunft der Arbeit. Und ich will an dieser Stelle vielleicht einfach nochmal die Gelegenheit nutzen, weniger was zum Thema, sondern ein, zwei Sätze zur Stiftung selbst, zu FES und zum Kompetenzzentrum zu sagen, weil wir doch bei Durchsicht der Gästeliste relativ schnell festgestellt haben, und dafür sind wir Ihnen dankbar und sind auch recht stolz drauf, dass wir quasi an Teilnehmerinnen und Teilnehmern nicht nur die üblichen Verdächtigen sozusagen erreichen konnten, sondern einen relativ breiten Kreis aus vielen verschiedenen gesellschaftlichen Bereichen an Leuten, die an diesem Thema interessiert sind. Daher gestatten Sie mir kurz was zur Friedrich-Ebert-Stiftung zu sagen. Diese ist die älteste politische Stiftung Deutschlands, wurde 1925 gegründet. Und ich weiß nicht, ob Sie schon mal von dem spezifisch deutschen Modell oder System der Parteienstiftung gehört haben oder der politischen Stiftung. In Deutschland ist es seit längerer Zeit üblich, dass jede der größeren demokratischen Parteien eine sogenannte parteinahe Stiftung hat. Was bedeutet das jetzt? Parteinah bedeutet, wir sind unabhängig, wir arbeiten unabhängig, wir tauschen keinerlei Gelder zwischen Partei und Stiftung aus. Aber auf der anderen Seite arbeiten wir natürlich ideell nahestehend einer bestimmten Partei. Und für die Friedrich-Ebert-Stiftung ist das eben die deutsche Sozialdemokratie und die deutsche und internationale Gewerkschaftslandschaft. Was sind die Hauptaufgaben der politischen Stiftung? In aller Kürze, die Stiftungen konzentrieren sich auf das Bereitstellen, das Anbieten politischer Bildung und politischer Beratung. Und das Kompetenzzentrum Zukunft der Arbeit nun wiederum fokussiert vor allem auf den zweiten Schwerpunkt, die politische Beratung, und das vor allem und fast ausschließlich im Themenfeld Politikfeld Zukunft der Arbeit. Was mich wiederum zu dem heutigen Format, nämlich dem Tech Talk Nummer 1 sozusagen bringt. Warum wollten wir dieses Format sozusagen kreieren oder was haben wir uns überlegt? Was waren die Beweggründe? Die Beweggründe waren, dass aufgrund einer Analyse sozusagen der Diskurse, der Debatten in diesem Themenfeld wir relativ schnell im Kompetenzzentrum festgestellt haben, dass wir der Meinung sind, innerhalb dieses Politikfeldes Zukunft der Arbeit gibt es einfach eine Unmenge an Buzzwords. Ich will jetzt nicht in Abrede stellen, dass es das in anderen Politikfeldern auch gibt. Das ist mit Sicherheit auch so, aber wir nehmen doch eine gewisse, eine ziemlich große Menge an Buzzwords wahr. Und bei diesen Buzzwords ist es so, also Beispiele sind etwa Industrie 4.0, Industrie 4.0, Sharing Economy, Gig Economy, Second Machine Age, nur um einige Stichworte, internationale Stichworte an der Stelle zu nennen, dass wir feststellen, verschiedene gesellschaftliche Akteure haben ein unterschiedliches Verständnis jeweils dieser selben Begriffe. Und das ist natürlich nicht förderlich für eine Debatte. Dementsprechend ist die Stoßrichtung dieses Tech-Talks, nicht nur dieses heutigen, sondern auch zukünftiger Tech-Talks, dass wir versuchen, einen Rahmen zu bieten, in dem komplexe Trends und Zusammenhänge in diesem Politikfeld aufgegriffen werden sollen und in einer einigermaßen leicht zugänglichen Art und Weise aufgefächert, diskutierbar gemacht werden soll. Und das bringt mich wiederum zum heutigen Thema, nämlich Digital Services Act oder vielleicht etwas breiter gesprochen Plattformen. Und ich gehe davon aus, dass wir viele Gäste, viele Teilnehmerinnen und Teilnehmer, mal abgesehen von den Expertinnen und Experten natürlich haben, die vielleicht ein bisschen Verständnis für Plattformen haben. Deswegen verzichte ich an dieser Stelle nochmal eine Typologie aufzumachen. Aber ich denke, es ist sicher zu sagen, dass Plattformen, digitale Plattformen, ein wesentliches Strukturmerkmal des modernen Kapitalismus, des digitalen Kapitalismus sind. Und ich denke, dass es ebenfalls sicher zu sagen ist, Plattformen tendieren zum Monopol oder zu einer Monopolbildung. Und das kann man jetzt auf der einen Seite gut finden, wie das beispielsweise Peter Thiel in seinem neuen Buch tut und erneut begründet. Peter Thiel ist ein ganz bekannter amerikanischer Investor, der allerdings auch Donald Trump nahesteht, der im Grunde genommen argumentiert, dass sich bei diesen Tech-Konzernen, wenn sie mal wirklich groß geworden sind, um sozusagen benevolente Monopole handelt, die zum Beispiel Verbraucherinnen und Verbrauchern zu günstigen Preisen gute Services anbieten, einfach weil sie es können, so, weil sie so groß sind sozusagen. Wir würden argumentieren, und ich bin mir sicher, dass das nachher auch nochmal Gegenstand der Diskussion sein wird, wir finden das nicht so gut, wenn diese Tech-Konzerne ein Monopol bilden, weil so ein Monopol auch immer Konzentration von Macht bedeutet, eine unheimlich große Konzentration. Und dass das nicht so gut ist, kann man, glaube ich, auch momentan an den Prozess, an der Diskussion um Facebook nachvollziehen, wo die Whistleblowerin Frances Haugen ja gerade ziemlich deutlich enthüllt hat, dass bei den Sachen, die in der Vergangenheit bezüglich Facebook diskutiert wurden, also ob sie die demokratische Meinungs- und Willensbildungsprozesse verzerren, ob sie Hassbotschaften verstärkt in Diskurse reintragen, alles Dinge, darüber gestritten wurde, ist das denn so? Jetzt wissen wir, erstens, ja, das ist so. Und zweitens, Facebook ist sich darüber auch völlig im Klaren. Das ist Teil von deren Geschäftsmodell. Und daraus, also das ist nur ein quasi momentan äußerst prominentes Beispiel, aber da kann man, glaube ich, relativ gut ableiten, Plattformen müssen in einem politisch gestalteten, in einem politisch regulierten Kontext eingebettet werden. Ansonsten führt das zu einer ganzen Reihe von negativen Folgen für Gesellschaft, aber auch für die Ökonomie. Und ein Beispiel, wie man Plattformen regulieren kann, ist etwa der Digital Services Act. So viel vielleicht an Vorbemerkungen quasi von meiner Seite, von Seite des Kompetenzzentrums, warum wir diese Diskussion machen. Mir bleibt an der Stelle nur Ihnen allen uns eine spannende Diskussion zu wünschen. Folgen Sie uns gerne auf Twitter, twittern Sie fleißig mit unter dem Hashtag, Samuel hat es schon gesagt. Und ich würde sagen, das ist nicht der letzte Tech Talk, sondern das ist nur der erste und wir würden uns freuen, Sie wiederzusehen. Thank you very much, Samuel. Now I'll pass on the floor again to you.
Wonderful. Thank you very much, Matthias, for your welcoming remarks there. And the Competence Centre really has joined the debate at a rather pertinent time here in Brussels with regards to the passage of EU digital policy. And you touched on a couple of other contextual points there with regards to the recent Facebook whistleblower allegations and also other legislative procedures going through the interinstitutional process at the moment, such as the Digital Markets Act, etc., which we may get the chance to talk about very briefly a bit later on. Nevertheless, we now move on to the discussion segment of today's event, in which we shall probe the ins and outs of the EU's grand plans to regulate the platform economy in the form of the Digital Services Act, otherwise known as the DSA, of course. So the European Commission presented the DSA in December of last year, and since then the bill has been making its way through the legislative process here in Brussels. There are many key issues at play, including the specificities of illegal content removals, how hate speech and disinformation will be dealt with, and the importance of the transparency of algorithms. To discuss some of these issues and as well, perhaps some of the areas in which the DSA doesn't directly tackle, but very much could do in the future, we are very pleased to be joined by a stellar panel this afternoon, which includes Athina Angeliki Tsitsou of the Digital Services and Platforms Unit at the European Commission's DG Connect. Thank you for joining us, Athina, this afternoon. We have Tiemo Wölken, S&D member of the European Parliament and someone who has been involved in the DSA discussions in Parliament's Legal Affairs Committee, also as well leading the committee's opinion on the Digital Markets Act. And we are also joined this afternoon by Aída Ponce del Castillo, Senior Researcher at the European Trade Union Institute. Thank you very much to all three of you for joining us here this afternoon. Just a reminder for all of you tuning in remotely that you can get involved with the conversation by posing your own questions using the Q&A function on Zoom. And please do let us know which of our panelists you would like to direct your question to. If you have any technical issues during this panel, we have a technical moderator on hand to help out as well. And a final reminder that German translation is available. And if we could also ask our panelists not to speak too quickly, then I believe our translations team would be very appreciative indeed. So without further ado, I think it's about time to jump straight into our discussion. And if I could first perhaps turn to you, Athina, representing the Commission, I wonder if you could explain for some of those tuning in who perhaps aren't from a technical policy or EU bubble background, why this legislation in the form of DSA is necessary. Why is it important today in Europe's digital economy, and which key areas of the online ecosystem will be harmonized as part of the plans?
Good afternoon, everyone. I'm very happy to be here with you today. So indeed, the European Commission decided to propose the Digital Services Act 1 year ago, in order to set a comprehensive set of rules which regulates the responsibilities of online intermediaries. And this can be many types of business models, from online marketplaces to social networks, collaborative economy platforms, and so on. Why it is important to have this act at European level is exactly because it will set one single set of rules in the single market, ensuring that companies can scale at home without having to comply with 27 different legal regimes, and without having to go through unnecessary legal burdens across the EU. The Digital Services Act proposal protects equally all users in the Union, both as regards their safety online when it comes to illegal content or illegal goods online, but also protects their fundamental rights. In this regard, the DSA sets clear due diligence obligations for all types of intermediaries, but it goes one step further, and by recognizing the impact of very large online platforms on our economy and society, it sets higher standards of transparency and accountability on how providers moderate and intermediate information. Last but not least, the DSA is also a foundational proposal for a true European governance of digital platforms. And the DSA enforcement mechanism reinforces the single market and enables cooperation between member states' authorities. So these are the main components of the DSA, and I'm happy to go into them as the discussion evolves.
Thanks, Athina. I just wanted to follow up actually with a bit of a contextual question. And I think it would be quite useful for our audience to get an impression about what the Commission's, or perhaps DG Connect's, response was regarding those recent Facebook whistleblower allegations. concerning the company's alleged half-hearted attitude to illegal and harmful content. How exactly were those revelations received by DG Connect and the Commission at large? And do you think there could be room of improvement in the DSA as a result of those specific allegations?
I think that what the recent events have shown is that they confirm that we are in the right track with the DSA. Arbitrary and one-sided action by platforms must be replaced by real due process information to users, possibilities and rights for redress mechanisms, and collective representation of consumers. We also need real accountability and scrutiny of platforms' decisions. We need transparency, real transparency, data access provisions, and all these are included in the Commission's proposal. These recent events have also shown to a large extent that it is really necessary and urgent to act on a European framework for such big platforms. And that's why we think that the DSA, now of course it is in the hands of the co-legislators, but we really believe that we should be quick in acting and putting in force a true European solution for all these issues.
Okay, thank you, Athina, for your response there. Tiemo Wölken, how do you respond to those comments there by the Commission? We're on the right track with regards to the DSA in respect to these specific allegations concerning the Facebook whistleblower. And also, Tiemo, I wonder if you could speak about your approach in the Legal Affairs Committee specifically, because that opinion was recently adopted, but I understand your political family wasn't too satisfied with the outcome, were you?
No, you're right. We weren't. But first, let me answer on the Facebook question. So yes, indeed. So we have even more evidence now of the harmful consequences of dominant platforms like Facebook on our society. And it's a showcase why the DSA ambition to increase especially transparency and accountability for very large online platforms is so important. And I really believe that we should use this wake-up call, hopefully it's really the last one we need, to even strengthen some of the rules proposed by the Commission. So for instance, on advertising, which is the business model, and I really don't get it why we are not talking about the business model of the platforms. So we know they are earning their money with ads, so we should regulate that. And as explained before, but we also need to discuss recommender systems, where I believe we should make sure that all users are recommended content not based on personal data and on profiling, unless they explicitly wish to. So, and I think this is and this is what I agree on with the Commission. So taking a look at the Parliament and especially the discussions in the Legal Affairs Committee, I need to say that I'm not happy with our opinion in the Legal Affairs Committee. So as you know, the S&D voted against it. We believe the opinion as it stands adds outright dangerous provisions. It creates loopholes, and it is in general inconsistent with the approach taken by the committee and the European Parliament in total in earlier DSA initiative reports. And you may recall there have been 3 initiative reports. And this opinion written by Mr. Didier from France really violates all 3 of them. So for instance, the opinion gives regimes like Poland and Hungary free rein to regulate platforms as they please, which could enable them to make platforms part of their propaganda machines. So by creating a wide carve-out for media content, The opinion also endangers the fight against disinformation and other harmful content. Furthermore, the opinion significantly weakens the prohibition of general monitoring for platforms and encourages platforms to use stay-down mechanisms for content that was previously removed, which would only be possible by employing automated tools such as the error-prone upload filters. And well, the discussions almost 3 years ago in the parliament on upload filters weren't the easiest ones, and I really do not want to repeat it. And lastly, the opinion calls for a 30-minute removal deadline for live-streamed entertainment content, such as live sports. And this is not only problematic because a 30-minute deadline is extremely short and too specific for horizontal regulation like the DSA, but also because it looks downright ridiculous if we compare it to the 1-hour deadline on the removal of terrorist content that Parliament and Council recently agreed. So, do we really want to send the signal that the commercial interests of rich organizations like football leagues are more important to us than the fight against terrorism? I don't think so.
Tiemo Wölken, thank you very much. Some strong words there against that EPP-led report in the Legal Affairs Committee. Tiemo, I just wanted to follow up on that. Do you see this as an EPP position reflected across other committees in European Parliament from your knowledge with regards to these dangerous provisions included in the Legal Affairs report?
As far as I know, it's not broadly reflected. On the other hand, all EPP members of the jury committee voted in favor, also including members, for example, from Germany, so Axel Voss, for example. But I don't believe that the majority would support this very extreme position, and because it really violates some ground principles, like for example, that we would empower governments to take down content in other member states, and I think this is really harmful. So well, we see differences, different approaches, for example, by Hannah in the ITRE committee. And yeah, let's see what the EPP decides in the end. But to be honest, I'm disappointed that the EPP completely voted in favor of the report, because they voted also for our committee's initiative report a year ago, where we had completely different positions. So this is a little worrying, to be honest.
Mm-hmm. Thank you, Tiemo, for your response there. Aída from the European Trade Union Institute, I'd like you to bring you in now to speak a bit more about the timeline, perhaps, of the DSA, because one of the challenges that a number of people have highlighted could be the very fact that it may take quite a while to get national governments to agree on the DSA, and of course, eventually later on in their trilogue negotiations with the European Parliament. So the forthcoming French presidency, Aída, have been very keen to make it clear that they'd like to reach adoption during their tenure at the head of the EU Council starting in January next year. You know, it's almost a legacy-defining text, many see, for Macron. Aída, how likely do you think this is, and how important is timing in terms of the adoption for the Digital Services Act?
Thank you, Samuel, and good afternoon, everyone. Yes, I think it is possible. I am very positive to that prediction in a way, because of two reasons. First one, France has always wanted a strong DSA, and they will probably use the presidency to push for a stronger text and then try to have it adopted during the period. So that's a very strategic move. And second, because France is trying to push through an amendment on online platforms by which they are already incorporating part of the DSA into their national legislation. So I think that these are very strong reasons to think that it is indeed possible to have a very short timeline. Also, we have to take into consideration that Commissioner Thierry Breton is behind the DSA. And this morning, in an interview on the French radio channel France Inter, I heard him saying that he was very confident that the DSA would go through during the first semester of 2022. And he said that 4 times during this short interview. So you can see here also the political intention of bringing this forward in a very short manner.
Mm-hmm. Thanks, Aída. And of course, we do have other, I suppose, semi-blueprints actually for DSA type techs in Europe. I'm thinking particularly here of Germany's NetzDG Act. And I wonder if these types of techs can provide any form of inspiration for how Europe should approach tackling things like hate speech or harmful content, etc. And do you think that could help things go along a bit more quicker from Brussels?
If the question is to myself, well, yes, it is a very interesting text, and there are many lessons that we can learn from the NetzDG. I am not really particularly familiar with it, but it has very interesting ideas. As Tiemo just mentioned before, there are in member states various ways to approaching thresholds, for example, on how to, the delays on how to bring content down. That is really something that we need, I think, member states need to agree upon, and the dangers that this brings with the limit, the freedom of expression, or whether there has been a truly or genuine legal assessment, whether that content was generating a threat or not. So this is what I can say about the German example so far.
Mm-hmm. Absolutely. Thank you, Aída. Athina, I'd like to bring you in again here to speak more about how perhaps we speak about how the DSA could affect businesses, but could it also create opportunities? I mean, how is it going to affect European businesses? But what opportunities could it also create for them, particularly SMEs in Europe? And what will be the biggest developments and changes that they will see on a day-to-day basis?
Indeed, I think that the DSA will affect European businesses in a good way, because exactly the DSA is an instrument at European level. It will set a common horizontal harmonized rule book for everybody, applicable throughout the whole this digital single market. So the DSA will give to smaller platforms access to a borderless single market without any legal fragmentation anymore. And this is very important for smaller businesses. This was the main challenge and the main concern that we've been hearing from small businesses also in the preparatory phases of the DSA, how expensive, how costly it is for them to comply with many different regimes, setting different rules across the EU. So indeed, it will create many advantages when it comes to the horizontal and harmonized framework, but it will also create a lot of legal clarity, because so far it's true that maybe some member states had specific rules, others didn't. There was confusion and legal uncertainty. Whereas now, because of the DSA, small and bigger platforms, all types of businesses will know exactly the rules that they have to abide with when they do businesses in the EU. And this does not apply only to European businesses, but also to providers which provide services to European citizens from outside the EU. So indeed, it will bring a lot of advantages, yeah, we are here to see how this will play out.
Okay, thanks, Athina. When we're speaking about the competitiveness of European SMEs, of course, another legislation that is hugely relevant is the Digital Markets Act. And Matthias, in his opening remarks, spoke about the challenge of monopolization of the platform economy. And Tiemo, of course, as well as the DSA, you have also been intimately involved in the Digital Markets Act. You, of course, led your own report on the DMA. Could you tell our audience a bit about the crossovers between the DSA and the DMA and the ways in which perhaps the DMA could help ensure fairness and contestability in online markets for European SMEs?
Yeah, I'm happy to do so. So first, I think it's important to distinguish between both files. Yes, they both partly regulate the same actors, so dominant tech platforms, but there are also significant differences between both laws or suggested laws. I think it is important to highlight that the DSA applies to all platforms, hence you could call it a digital constitution. It's not focusing only on big ones. So it is very dangerous that many colleagues approach the DSA as if it applies only to large platforms, when really we are also regulating startups, medium-sized companies. And in the end, we need rules in the DSA that all actors can apply. So otherwise, we just make sure that Facebook, Google, and Co. stay dominant because no one else can afford to run their platforms in Europe. And again, we did this mistake with the copyright reform, because we introduced these filters which really can be handled mostly by Google and Facebook. So the DMA very specifically focuses on the large and dominant platforms on the other hand, and proposes very specific remedies to real problems like unfair competition on marketplaces or unfair default settings on our phones. And unlike the DSA, it does not set out a general code of rules and requirement, but it fixes issues that are specific to the dominance of certain platforms. So while we need to make sure that both laws fit together, we should not treat them as one and the same because they really have different objectives.
Mm-hmm. Thanks, Tiemo. And what do you make of the scope of the DMA? I mean, is it would you support a broader scope with regards to the platforms that come under this gatekeeper moniker, or would you prefer more of a targeted approach?
Well, I think that the DSA should first catch all platforms, all gatekeepers, sorry, catch all gatekeepers. And I think it's dangerous to limit the application of the DMA. So if necessary, we need to expand the scope of the DMA. And this is what I really believe. In the rapporteur in IMCO, unfortunately, seems to limit the application of the DMA to already existing dominant platforms. But I think that this would repeat a mistake. So we need to be able to foresee in the future. And for that, we need some flexibility, and we just can't only try to regulate existing platforms. So in jury, I think we found a good compromise. We have a close list, but we can expand this list to new services, for example, like virtual assistants. And I think it's we should do it to be as technological neutral as possible, because no one can tell what the future brings. But I think it would be a mistake to only design the DMA to regulate Facebook or Amazon and Google. It needs to do that, but we should also have flexibility for the future platforms like Google and Facebook, which no one can predict.
So what you're really trying to do there is make this legislation, I suppose, future-proof, to ensure that there's a wide catchment area.
That would be the buzzword, yes.
Right. Okay, great. Aída, I'd like to bring you back in now to speak about something that is not actually in the DSA, but perhaps we can think about why it's not there. And this is, of course, when we talk about employment opportunities, employment rights of platform workers, etc. And I wonder why, in your opinion, is the DSA not aiming to necessarily empower workers of online platforms and their rights? And if it affects businesses subsequently, shouldn't it also affect workers' opportunities?
Yes, Samuel, and this is the biggest disappointment of the Commission's proposal on the DSA. So why does the DSA not include platform work or the employment dimension? And the answer is that because it is not a worker protection legislation. The DSA is a legislation for the proper functioning of the internal market and secondary, the protection of fundamental rights. But it's not about empowering workers at all. I think also these are two aspects, worker protection and the employment aspect of that has been really left outside, with knowing that a large proportion of how platforms work is driven by the data and the activity that platform workers do. And they are the invisible actors in the platform economy at the moment, but the ones who are suffering the most because the working conditions, the employment status is completely damaged at the moment. So this is what I can say. On the other hand, we know that there is an ongoing stakeholder consultation, or social partner consultation, to be more precise, about the working conditions of platform workers, which is ongoing, and the negotiations between employers' associations and trade unions are, with the Commission, are quite interesting and tense. And there are many things that are really linked to the DSA, which should be treated there and which are not. For example, algorithmic management and the lack of accountability and the opaqueness of algorithms telling workers when and what to go, or even dismissing workers. I think that should be dealt necessarily within the DSA and not be left to a consultation, which results we might not see very fast, or which results might not be in line with what the DSA might have. We are not sure whether the outcome of the social partner consultation will result into a legislative initiative. This is what I wanted to say.
I'd like to bring in Athina to respond to a couple of your points in a moment, Aída, but just to follow up on one particular thing you said there with regards to the stakeholder consultation that obviously comes before the announcement from the Commission in December on an initiative for improving the working conditions in platform work. I assume, Aída, you've been involved to some extent in this stakeholder consultation. Maybe you can give us an insight into the points of resistance, the differing opinions from industry representatives, from civil society, from the trade unions, and what sort of a response are you getting from the people you talk to in Brussels, both in the European Parliament or your contacts in member state governments with regards to this particular point on securing the employment rights of platform workers?
Sure. So one of the biggest points of contention is, of course, the status of the worker, whether it is a worker or not. That's the biggest contentious point. And here, the European trade unions are very clear in their position, which is also sustained by legal experts and some national courts as well. The burden of the proof should be borne by the company, for example, the platform, who should really abide to the labor or social protection and fiscal obligations as an employer. It's the platform who is hiring a worker to work for its business model. Also, it's the platform who should perhaps abide and recognize the sectorial agreements negotiated within collective bargaining by social partners. We have, since June last year, the Autonomous Social Partner Agreement on Digitalization, containing chapters on privacy, data protection, algorithmic management, artificial intelligence. And this is the first, of course, autonomous agreement, very important. And it's not within the language and the narrative of the online platforms. It should be recognized. A second point of containment is related to the social dialogue and collective representation. As you know, the biggest online platforms are owned by non-European owners, and they are sometimes, or very often, they don't recognize trade unions, or they even reject the possibility to have trade unions in their inner workings. We have seen that with Amazon, and we have seen the reaction of some tech workers unionizing in the US, excuse me, and we have seen that movements coming up from tech workers and initiating some collective action. In Europe, we have managed to, or trade unions have managed to talk to already to some online platforms. It was not a difficult, and it was not an easy way. They are not the normal category of employers, if you like. So this is also one point of contention, to be able to recognize that workers can have a collective voice and a collective representation and engage into social dialogue. And the third point, which might be very technical and not, but it's the way the business model is constructed, is the algorithm behind the management, the platform, or behind the app, whatever we call it. The way through which workers are being allocated jobs, assign a fee, assign a job, or refused a fee, or even being dismissed. We cannot so far apply GDPR Article 22 or even the right to access in order to contest the decisions that are made by these opaque algorithms. It's very difficult to apply the right to access or restriction sustained by the GDPR within the employment context. So this is a very difficult question, and the nature in which the algorithm is entering into their industrial relations and even having more capabilities than a normal manager can have, it's really dehumanizing not only the platform worker itself, but the whole of industrial relation. And this is something that labor law, of course, is not equipped now to address that. Mm-hmm. And perhaps I am a very, I really believe that some sorts of algorithms should be banned, mm-hmm. particularly those who are dealing and making decisions regarding the facial expressions, the biometrics of a worker, and then assuming or predicting outcomes out of that interpretation, which is obviously not neutral, not open to audit or criticism or contesting.
Mm-hmm. Okay, thank you, Aída. Just a reminder as well to our audience tuning in, please do send your questions into us on the platform, highlighting who you would like your question to be directed to, and we shall pick those up as they come through. Athina, there's a lot to unpack there in terms of perhaps why the Commission decided not to directly tackle platform workers' rights in the DSA. What's your response to some of the things that Aída said? I mean, particularly the predominant thing is, I suppose, agreeing a definition for what a platform worker actually is.
So I have to say that I agree in most of the things that Aída said as regards the reasons why we haven't addressed specifically platform workers' rights in the DSA. And this is primarily for two reasons. First of all, the DSA is a horizontal instrument which seeks to set the rules for a functioning internal market. It's not a labor law instrument as such. So we could not possibly regulate specific issues about platform workers in an internal market instrument. This does not mean that some of the provisions in the DSA might not have an impact on digital labor platforms. It could be that some provisions regarding transparency or algorithmic management could have an impact when we talk about digital labor platforms where providers upload, let's say, illegal content. But this is quite marginal. I understand that this is not the main concern when we talk about workers' rights. Having said that, we recognize, and the Commission's president has been very adamant in saying that we need to improve the conditions for platform workers in the EU, and that's why the whole process of the social partners consultation has been initiated. The second phase, the second stage of the social partners consultation has come to an end last month, and now the Commission is reflecting on the outcomes and the feedback that we received from this consultation, and we are thinking currently about a potential legislative instrument which will tackle especially the issues of platform workers. So in a sector-specific instrument which will focus on these issues, this might be possible. And all these elements that Aída referred to, which is the employment or not relationship between the workers and the platform, algorithmic management when it comes specifically to the way workers are being treated in platforms, as well as the possibilities and the clarity around the collective bargaining are being currently thought through by the Commission. So yeah, I'm afraid, and indeed, one of the most difficult issues, I think, is to determine when a worker is actually an employee of the platform and when it's not. But this is an ongoing process. These are the issues that we are currently thinking about. It is our colleagues in DG Employment who are in the lead for this initiative, but of course we are also very much following it and try to ensure complementarity with the DSA yeah.
Great. And Athina, this legislative instrument that you're speaking about, this is the early December announcement on an initiative for platform workers, I understand. What sort of a contextual relevance will this instrument have? I mean, under COVID, we've all turned to digital services so much more than we did before. We've all used platform workers, perhaps in an unprecedented manner. How much of that has been at the centre of the thought in the Commission with regards to this instrument?
It is true that the COVID has really shown how much our society is dominated by online platforms. And this is not only relevant for the initiative on platform workers, but it was also for the DSA, for the DMA, and that's why it's also very urgent to act upon the proposals that the Commission has tabled so that we come forward with European rules. So indeed, the COVID pandemic has even more accelerated this process and has shown that something needs to be done when it comes to online platforms.
Okay, thanks, Athina. We have a question here from the audience, and this comes from Nora Rode from DGB. It's addressed to either Athina or Tiemo. Perhaps, Tiemo, you can take this one up. And Nora asks, do you consider the current talks on e-commerce at the WTO level a threat to the implementation, the final implementation of the DSA. The talks seem to go in the opposite direction when it comes to, for example, the transparency of algorithms, data regulation, accountability, etc. Tiemo, that one has been addressed to you. Perhaps you could pick it up.
Yeah, I can try, but a word of caution in the beginning. Of course, I'm not a member of Inter, no. My answer would be that the talks on e-commerce at WTO have been going on for a while, but it has always been the line of the European Commission, if I'm not mistaken, that they would only agree to a solution that is compatible with EU law. So therefore, I expect the final outcome will be in accordance with the rules set by the DSA and the DMA. So this is what I would believe, what should happen. And I can see that Athina is nodding. So that's good. Again, so I know it's a very long and ongoing issue. And I think we should use this opportunity, which we have now with the DSA and the DMA on the table. And the whistleblower, Facebook whistleblower case, just again, as we already discussed today, highlighted that it is important to increase dramatically transparency, especially of algorithms, and increase accountability of platforms. And this is what we're aiming for with the DSA.
Mm-hmm. Great. I'm well aware of the fact, actually, that we are rapidly coming to the end of today's session. We have about 6-7 minutes left. But before perhaps we close, it would be remiss of us not to consider how the DSA will impact Europe's digital economy for the future. And perhaps, Athina, if we could turn back to you, what is the long-term vision here from the Commission with regards to how the DSA will help affect or create favourable conditions for the rollout of Europe's digital economy in the future? Of course, bearing in mind these digital compass targets as well for 2030 that aren't so related to the platform economy, but they may have a relevance to the DSA. And what really are your overarching expectations for the future with regards to the DSA?
Thanks. Yes, there are many things to say here. First of all, according to our analysis and our impact assessment, the new rules that the Commission has put forward are projected to foster an increase in cross-border trade in the EU between 1 and 1.8%. So we do believe that these new rules will improve the current framework and will help businesses innovate and startups go cross-border, and will not be anymore, the regulation will not be anymore in the hands only of very large platforms, which can be the only beneficiaries of a very fragmented regime. Second thing that I wanted to say, which also comes back a little bit to Nora's question, is about the global impact that the DSA might have on at global level. We have seen in the past that third countries are copying rules from the EU. So it is an inspiration from other countries. We have been now in discussions with the US. You might be following the EU-US Trade and Technology Council, which met for the first time in September, and where a working group will specifically address and discuss the issues around governance of online platforms. So there again, the EU has the potential to influence developments at global level. Here, what is important to mention, I think, is that the rules, the European rules, can be copied elsewhere, but can be also copied in regimes and in countries where they might not have such strong democratic underpinning. That's why we should be very careful, and we should make the utmost of including the necessary safeguards in the DSA. So overall, the Commission's goal was to set the ground rules for an effective governance of online platforms. And we hope that in the end of the legislative process, this will be the case.
Thank you, Athina, and thank you for joining us here this afternoon. Tiemo, of course, some of Athina's points there reminded me of what you said about earlier when we're speaking about the risks specifically of the legal affairs report and perhaps the DSA being abused by governments that don't have a necessarily strong democratic underpinning at the moment. Of course, this has been something in the news, particularly over the past couple of weeks in other areas. But Tiemo, hearing those expectations from the Commission and bearing in mind the current context, do you believe that the DSA that we will end up with will deliver on those objectives from the Commission?
Well, I hope so, and we, as the Parliament, we will make sure that in the end we deliver. Because, as I said, this is the last opportunity, the last chance we have. So this is the last bullet we have, to be honest, it has to be a success. And I think that the Commission indeed presented a proposal which was in line, well, mostly in line with what the Parliament requested in the 3 initiative reports. And this doesn't happen all the time. So I'm really happy about the fact. It's a pity that some rapporteurs have been changed. So normally it's the rapporteur of the initiative report taking over the legislative work in jury, for example. This gentleman's agreement has been destroyed maybe by the EPP. So when they choose to bid for this proposal and to name CTDA, and but that's only one small opinion. And in the end, the discussions in IMCO are ongoing. They are progressing slowly. And one final sentence maybe. So as I said, this is the last chance. We have to do it absolutely right. And as the things stand at the moment, the plans are that we vote in November. But I would argue that before we vote on something which is not completely discussed, which is not completely thought through, we should not vote in November, but maybe delay the votes by a few weeks to deliver a very good proposal from the Parliament side. And yes, the French presidency is really eager to close the deal on the DSA. But if we, for example, take a look at the not GDPR, sorry, on the sorry?
E-privacy?
Yes, e-privacy. It was out of my head. So e-privacy, we are discussing this for almost 5 years now. So I really think that from all what I'm hearing also in the council, there are different views, different positions. It will be quite a long way to the final legislation. And again, if we have in the end a good piece of law, then I think it's worth to wait the extra weeks or month. So yeah, I'm not sure. That's the bottom line. I'm not sure if the very ambitious timelines in the end will be held.
We'll have to see if Macron gets his wish. But I do hope, I mean, Tiemo, you referenced the copyright directive earlier, and that was a very, very divisive debate indeed. I really hope it doesn't get that bad with the DSA, because that was quite, there was a lot of vitriol going back and forth. Let's have a more mature debate this time around, hopefully, but who knows? we shall have to wait and see. Aída, coming at it from the perspective of the trade unions, obviously securing these platform workers' rights isn't something necessarily covered in the DSA, but I wonder if you've perhaps felt a bit at ease with what Athina's said today, and if this isn't something that is being covered by the DSA, how can we ensure that ensuring the rights of platform workers isn't a general blind spot in EU digital policy for the future?
Okay, so first and foremost, I think from the Commission perspective, or looking at the Commission and how it functions, I think that the first step is to put DG employment in contact with DG Connect, if you know what I mean. DG employment needs to have a much more say, and I know that all DGs talk to each other and they arrive into a compromise, but I think in my interpretation so far, the interests of DG employment haven't been really taken into account or even haven't been expressed. So that's the first thing to do, so that they could really play with it at equal level and not just only drag the boat to the single market and constructing digital and unpalatable single market, which is the big ambition of the Commission. And employment perhaps it's somewhere there, but it has to be taken into account in drafting the laws. Also at the same level at the European Parliament where Tiemo plays, and at the Council, these issues about employment should be taken on and discussed. We have seen that already some MEPs are interested in the issue. So that's really a great sign of that. So that's the first stepping stone. And the second one, well, I really think that within the negotiations, a chapter on the employment dimension of online platforms could be well negotiated within the DSA. We have all the possibilities to do that. And as Athina said, there are already some overarching common topics that could become more explicit legal provisions within the DSA. And if that doesn't happen, and if the Commission decides to put forward a directive or another instrument, well, I hope that it will be done at the same time or within the same time frame, because all of these issues that are being left aside on algorithmic management and the health and safety and working conditions of platform works need urgent action. Again, some practices need to be banned, absolutely. Some algorithmic decisions that are really surveying and scraping the workers need to be banned. And this is something that needs to be done in a legal harmonized text, I suppose.
Mm-hmm. Wonderful. Thank you very much, Aída, for your closing comments there. This conversation could go on for much, much longer, but unfortunately this time around, we have come to the end. You're very lucky indeed for the fact that there will be more tech talks held by the Friedrich-Ebert Foundation going ahead, and the next one will be coming up at the end of November, so do keep an eye out for that one. So today we've heard a lot about how the DSA may be able to create opportunities for SMEs, the DSA's potential role in ensuring a fairer working environment for platform workers, and perhaps how the DSA may impact Europe's future digital economy. A big thank you to our panelists for taking the time out of their busy schedules to join us this afternoon. And thank you to all of you tuning in remotely for your contributions and questions. And finally, thank you to the Friedrich-Ebert Foundation's Competence Centre for the Future of Work for hosting today's panel. If you'd like to keep in touch with the future events to be held by the Foundation, please reach out to oliver.philip@fesmoie.eu. I think you will find the email address written somewhere in the chat, and you can stay up to date with all the future events from the Competence Centre with Oliver. Thank you very much for joining us again this afternoon, and we will see you next time.
Thank you so much. Bye-bye.
Thank you.
Thank you. Thank you, Athina and Tiemo. Thank you, Samuel.